back to the Compliance Kitchen. Today we will take a look at the EU Blocking Statute, and there's an effort underway to amend the statute. So let's take a look at what's going on with that. So on August 20th, or about August 20th, I'm not sure that was the exact date, but the EU issued a notice of an initiative opening a public comment window in regards to its planned amendment to the blocking statute. The comment period actually goes through August 30th, 2021, so a few more days, and then the window will close. And some of you guys may know that, or I should say, there is a post on Compliance Kitchen about the EU's Advocate General's opinion on the EU blocking statute, and this was issued in connection with the litigation that was Bank Melli Iran versus Telekom Deutschland. And so if you want to take a look at that, I have links to those posts and also to the EU's Advocate General's opinion on compliancekitchen.com. And so in regards to this amendment initiative of the blocking statute, the European Commission tells us they have a so-called roadmap document that in recent years certain third countries have increased their use of sanctions or other regulatory measures to restrict the conduct of legitimate business of the European Union and its individuals and companies outside the territory of the country adopting them in situations where a legitimate connection with the prohibiting country does not exist. So, for example, some of those third country sanctions prohibit EU persons from doing business with certain other third countries and their nationals, even if that business is not prohibited by EU law and lacks a legitimate connection with the country applying the prohibition. These measures are considered to have an extraterritorial application, which the Commission tells us is in breach of international law. They refer to it as extraterritorial sanctions. And such measures, or simply the threat of imposing them, have resulted in significant economic damage to the EU economy, as was evidenced by a number of studies. So, by way of background on these extraterritorial sanctions, the EU did not recognize these sanctions or the application of them by third countries and considered them contrary to international law. It viewed the application of these extraterritorial sanctions as unlawful because they produced effects outside the territory of the country that was imposing them without any nexus between the issuing country and the affected country. So in response to the extraterritorial sanctions, this was back in 1996, the EU adopted Council Regulation number 2271/96, or the so-called blocking statute, or the regulation. So you're probably familiar with the term blocking statute. And the purpose of the blocking statute was to protect EU market participants from the applicability of these extraterritorial third country sanctions. So what the blocking statute prohibits is compliance with these third country sanctions. It also nullifies the effect of the EU in the EU of any foreign court ruling or administrative decision based on the extraterritorial sanctions, and it also allows EU operators to pursue a court action in order to recover damages caused by the third country sanctions. So with this little background on how the blocking statute came to be, the European Commission tells us in their roadmap document that certain countries have caused economic harm to the EU by imposing these prohibitions on EU operators even when the prohibited activities are purely intra-EU and unrelated to the third country. And not complying with those prohibitions can result in restrictions or even exclusion from that third country's markets, infrastructures, or the use of its currency. So as you may know, for example, the US has so-called secondary sanctions, right? And so these are sanctions that can be imposed by the US government on foreign companies or individuals if they engage in dealings that are contrary to what the US determines to be in its best interests. And so, for example, let's take a European company doing business in Iran. So under European law, that should not be problematic, but under the US law, it is. And so the US secondary sanctions can be applied to this EU company. And as the Commission tells us, as a result, this EU company can be excluded from banking with US banks, doing business with US companies, using the US banking system, can be locked out of correspondent bank accounts within the US banking system, and so forth. So the Commission further notes that such third country sanctions have a number of damaging effects. They threaten the integrity of the EU single market and its financial system, put strain on legitimate EU trade, investment, and financial operations in violation of the basic principles of international law, and they also reduce the effectiveness of the EU's foreign policy. And not the least consequence, they generate substantial economic losses to the EU. So the Commission believes that the time has come to review and revise the blocking statute so as to kind of fine-tune the statute in the light of new realities, such as the increased reliance on global infrastructure and value chains, the EU operators' frequent exposure to certain third countries, and the proliferation of extraterritorial sanctions and their increased complexity. Without such an intervention, the EU believes some of its market operators could lose access to foreign markets, and so they opened a comment window. It is closing in the next few days on August 30th, and after that, the Commission plans to assess the comments and move forward with this amendment or revision initiative.